Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we got more big news, but this time it is not good news. Now, if you are part of the hometown crowd out here in the state of Washington, you already know about it. And if you think I didn't do a video, Washington, yeah, we did a big live event that night, the night the ruling came out. It will be linked up down below so that you guys can geek out on it. But we had a huge ruling out of the Washington State Supreme Court as it related to, a magazine ban. But what I really want to talk to you about, America, is I want you to be aware of how the state Supreme Court ruled. We're going to compare it to what's being argued in Illinois, and I'm going to tell you that this is a very dangerous argument, and one that if it is not on your doorstep yet, it could be there in the very near future. So today, let's spend a few minutes and let's talk about the state Supreme Court that just upheld magazine bans. Okay, so like I said, this is a video for the hometown crowd or anyone else around America who wants to wallow in our misery, or anyone living in a state where you're a little concerned that there is more and more push for civilian disarmament, because if in fact you're going to be challenging magazine bans, or if you're going to be challenging assault weapon bans, this is an argument you're going to have to deal with. Now, on a side note, there was a fantastic dissenting opinion, so we will be doing a separate video on that, because that's going to teach you how to undo this argument. The case we're talking about today is State of Washington versus Gators Guns. Gators Guns decided that Washington's magazine ban was unconstitutional, decided to sell them anyways. The state of Washington busted them for it. They crapped their pants. Gators sued the state of Washington, and at the trial court level, the law was found to be unconstitutional and enjoined for all of 88 minutes before the Washington State Supreme Court got themselves involved, and you kind of know where we were going from there. Now, we did this video the day of oral arguments because we were down in Olympia for oral arguments, and we predicted that we were going to lose 8-1. The one justice that I thought would actually vote in our favor ultimately did vote in our favor and authored this really fantastic dissenting opinion. I was wrong, however, because we actually lost by a vote of 7-2. So Justice Gordon MacLeod, the author of the dissenting opinion, actually found that this law was in fact unconstitutional. Everybody around the country, you need to understand what the Washington State Supreme Court did, because it's exactly what the state of Illinois and Barnett v. Raoul is arguing this exact moment with their opening brief over in the Seventh Circuit. And this is essentially how the argument goes. And I want you to understand this, because this is how they work around everything, and this is how they inject their own interest balancing back into it. The test, according to the Washington State Supreme Court, is this. 1, the Constitution protects arms in common use for self-defense. 2, if it's not necessary for the function of the firearm, or we believe it is not appropriate for self-defense, we can ban it. And finally, number 3, you don't get to decide what's appropriate, we do. Now, even though there was a challenge to this law under both the federal Constitution and the state Constitution, when the court decides that they get to decide what's appropriate for self-defense, and therefore if they believe it's inappropriate for self-defense, there's no Second Amendment protection at all, well, you get to make rulings like this. We hold that Senate Bill 5078 does not violate either the Washington or United States constitutional protection of the right to bear arms, because large capacity magazines, LCMs, are not arms within the meaning of either constitutional provision, nor is the right to purchase LCMs an ancillary right necessary to the realization of the core right to possess a firearm in self-defense. And again, by limiting Second Amendment protections to only instruments that they believe are appropriate for self-defense, the court then can rely on a case about a paring knife to hold. The right to bear arms protects instruments that are designed as weapons traditionally or commonly used by law-abiding citizens for the lawful purpose of self-defense. In considering whether a weapon is an arm, we look to the historical origins and use of that weapon, noting that a weapon does not need to be designed for military use to be traditionally or commonly used for self-defense. We will also consider the weapon's purpose and intended function. And because the court then can find or determine that large capacity magazines are not commonly possessed for self-defense, then they can also find that you don't need them. And since you don't need them, that translates to you don't have a right. Or as the Washington State Supreme Court puts it, we conclude that LCMs are not protected by Article 1, Section 24 because 1, LCMs are not instruments designed as weapons. 2, LCMs are not traditionally or commonly used for self-defense. And 3, the right to purchase LCMs is not among the ancillary rights necessary to the realization of the core right to bear arms in self-defense. That's right, the court wants to put state government in a position where they get to be the all-knowing authority on what's appropriate for self-defense, and anything that they believe that is not appropriate for self-defense, you don't need. Further, it is not factually accurate to say that LCMs are an integral component of firearms. Although the parties agree that certain types of firearms require the addition of a detachable magazine to function, Senate Bill 5078 does not regulate detachable magazines. Senate Bill 5078 regulates only large capacity magazines that are capable of accepting more than 10 rounds of ammunition. And Gators admits that no firearm requires a magazine of this particular capacity to function. Thus, LCMs are not required for a firearm to function. But the court leaves a very, very scary sentence back in here, which is, hey, they probably are not done upholding limitation sizes, because the court specifically stated, we have never held that magazines are arms, and the fact that a semi-automatic weapon will not function as intended without one does not conclusively establish that they are. And again, they are literally leaving breathing room for a state to limit rounds to 5-round magazines, 3-round magazines, because again, the Washington State Supreme Court, now that they believe that they have this huge interest balancing of we get to determine what's appropriate for self-defense, well, they can make statements like this. The argument that magazines are protected because they are an integral component of a certain type of firearm is further troubling because, logically, the fact that government could not ban an entire class of firearm component without impairing the right to bear arms does not mean that the government is not permitted to restrict a specific subclass of that component. So where do we stop? 10? That's where we're at right now. Is it 7? Is it 5? Is it 3? Is it 2? Where is it? Because you know where some of these states are going to take it. And ultimately, this whole bastardized, this fictionalized in common use for self-defense allows the Washington State Supreme Court to rule. LCMs also fall outside of either protection of the right to bear arms because the provisions protect only those arms that are commonly used for self-defense, and we have been presented with no credible and persuasive evidence or argument that LCMs are commonly used for such a purpose. And trust me, what they will do, and you could dump a million facts at them, or they could just do what a responsible court would do and just realize that, are large capacity magazines in possession for all lawful purposes? Yes, they are. It's as common as what? The sun setting in the west every day. But the Washington State Supreme Court, you see, with this new escape hatch that they built by in common use for self-defense, they get to rule. No showing has been made that the origins, use, purpose, or intended function of LCMs support the conclusion that they are commonly used for self-defense, and thus we hold that they are not within the scope of the right to bear arms under the Washington State and United States Constitutions. That's right. That in common use for self-defense gives the state actually here 2 outs. Number 1, the court can just say, we just don't think it's appropriate for self-defense. Or the state could just say, well, you just never actually proved on the record that it's used for self-defense. But, we had Lucy P. Allen, who's gone from 2.3 to 2.2 shots, and I'm sure it will depreciate from there. So at the end of the day, America, I want you to understand that nobody out here in Washington State was actually surprised by the ruling. I think we were only surprised that we actually lost 7-2 rather than 8-1. And again, kudos to Justice Gordon MacLeod, and we do have a very important video coming up about that. But you need to understand that this in common use for self-defense now allows any state hell-bent on civilian disarmament not 1, but 2 end-arounds from their constitutional obligations, because they can either just say that we don't believe it's appropriate for self-defense and therefore there is no Second Amendment protection, or even if you say it's in common use for self-defense, you haven't established it by enough evidence that we would be convinced. And either way you cut it, the constitutional mandates of not only the Second Amendment, but very clear case law, including Bruin and Heller, can be ignored. Okay, the case once again is State of Washington versus Gators, Customs, Guns. We're gonna link up the opinion down below. Washington, you guys all know the drill by now. 3 fingers of bourbon, breathing exercise, or barf bag. You're gonna need one of them. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information down there in the description box. If you got an idea for a video, you click on that link and you tell us all about it. If you want to subscribe to the monthly newsletter, you sign up by looking at it right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.